Everybody in the gallery needs to be quiet, please. The defendant's on the stand. The jury's not present. The jury's not in the courtroom. There are a couple sidebars. Let's make this brief so we can get the testimony done with this witness. Then I want to discuss scheduling. Mr. Ahmad.
At this time, defense is moving for a mistrial on the grounds that there was discussion of his open pending cases. We don't believe that the door was opened to that specifically to mention that was a criminal case. I understand what the state's argument was that he has other attorneys and that they potentially could have assisted him in turning himself in. And I think that should have been where it ended. But then to start talking about the criminal cases, that it's Waukesha, that, you know, there's been some testimony in this case so far that he was also on bail. One of the officers did mention bail. I think maybe it was alluded to some level here in the testimony. I think given the current circumstances and the climate, all of that would be grounds for a mistrial. So I want to make a record of that at this time.
Mr. Huebner.
First of all, Your Honor, the court had already ruled previously during numerous final pretrial motions that the state would be able to bring in the fact that the defendant had 2 court dates that he missed because it went to consciousness of guilt. The fact
That's correct. That ruling was made at multiple pretrial hearings.
So
yes.
The fact that the defendant had court dates was going to be admissible. That was going to be the intent of really all my questioning until the defendant then decided to make a big deal out of the fact that he remained out of the state trying to get legal representation. My point was, well, he had 2 lawyers. Had he just acknowledged that and that he could have called them and didn't, I would have been done. But the defendant kept acting as though he didn't know who they were or that he had lawyers, and then even went so far as to say he didn't even think they were criminal defense lawyers. I would note that every single one of the steps along the way that the state took was only after the court in chambers told the state they could. In fact, the court, quite frankly, I think I could have even gone further. I didn't mention the charges. I didn't mention whether or not they were felony or misdemeanor. I didn't mention that there was a gun in one of them and that the other was domestic violence. I stayed away from all of those. I tried to get through that portion of it as quickly as I could. And I just couldn't based on the sheer evasiveness of the defendant's answers.
Right. Let me step in. The defendant testified repeatedly, and you know, I'll leave the assessment of his veracity to the jury, but he testified repeatedly, at least the state would argue, feigning ignorance of having other matters pending or proceeding. Then he, on more than one occasion, again, maybe accurately, maybe he was feigning ignorance, he, knowing that he had attorneys on those matters, said, well, I didn't know that they were criminal matters. We discussed it off the record, and as I said, on the record in less than a sentence, yes, I believe then and still believe that the defendant opened the door to additional examination. Arguably, again, the determination of veracity will be part of the calculation and reviewing the evidence, the testimony, the witnesses for the jury, but arguably the defendant was clearly lying and or feigning ignorance. As the state noted, I think the state could have potentially went further. They didn't. It's probably fine that the state did not go any further. But as part of my analysis, the defendant sat on the stand and said repeatedly, effectively, I don't have an attorney, I didn't know I had attorneys, and then even went as far as to say he didn't know he had criminal defense attorneys. As I said off the record, that's hard to believe when someone had at the time a pending misdemeanor with 6 counts that involved allegedly a weapon, and he had a separate domestic violence case, one of them at a misdemeanor level, but with 5 or 6 counts, based on what the state's told me, the second one a felony level case. for the defendant to continue to at least potentially evade or feign ignorance on that, he opened the door to expanded examination by the state. It was valid, it was legitimate, the motion for mistrial is denied. Now, I'd like to discuss scheduling. Gentlemen, I've been telling both sides for the last 2 days, it may have actually started on Friday, that we need to move things along. I told the jury last week we'd be done by Monday. It became apparent probably last Thursday or Friday morning that Monday was not a reasonable goal. But here we sit at 2:50 on Tuesday. So we need to move the case along. I have encouraged both sides to move it along multiple times. I've not cut off questioning, at least not in the broad scope of questioning. But the jury will come back in, we'll conclude with this witness. Is this the defense's last witness or not?
There's just Dr. John Black, which should be concluded today.
And is the state planning any rebuttal? I guess I don't need a final answer now, but I'd like some inclination, please.
I'm inclined to, but it wouldn't be long even if we did.
Would not be long, is that what you said?
Yeah, Your Honor, it's the only rebuttal
You
testimony.
use the mic again, please.
Yeah, I'm sorry, I keep moving that thing. Judge, the only potential rebuttal testimony that I might have would be 2 to 3 opinion witnesses. They're simply the character witnesses that I previously noticed. You know, since it's opinion testimony, there's really not too much I can get into other than their opinion as to the victim, whether or not, you know, he would say certain things. It would be fairly quickly, I think, if I did it. And I can't see more than 5-10 minutes of witness. We've got 3 of them. They're already here. They're already lined up.
All right, bringing the jury in, the defense can do redirect, then the state can do recross, then I'll send the jury out. The defendant can obviously be off the stand and back at counsel table. Then I'll expect the defense's last witness. I expect to be done with at least that testimony, the defense case, by the end of the day. That's 2 hours. That should be plenty of time. Let's proceed. I'll have the jury brought in